I would just like to welcome everyone here tonight. Thank you to SWAT Law for being in attendance this evening again. And it just gives me great pleasure to introduce, many of you have, might not know, Ms. Zintle Novazi is one of our colleagues here at the Faculty of Law and is currently in the throes of the first semester, the new compulsory module, Law and Technology 414, in the first semester, has 2 masters, because why would you only want to do one, at WITS in tax, and then and then saw the wisdom of her ways, and then moved into technology, media, and telecoms, and that was through the University of Queen Mary over in London, and has joined us now. And you've been here a while now, Zintle. When did you first arrive?
1st of July.
Last year already, eh? Goodness, time is flying by. So if you haven't yet reached your final year, you will soon, one of these days, see Ms. Strauss and Ms. Novazi. And then also Marie Lowe from SWAT Law, also an alum of ours, and is now at SWAT Law. And they are going to be talking to you today about data protection and automated decision making and the like, and both of them are going to have an opportunity. Zintle is going to start, and then we'll do stuff and then transition over to Marie. So very informal, but I think at this point we're good to go in terms of our recording. You've just got to share. Are you sharing?
You have to share
on the Teams meeting. Yes, you've got to share. Otherwise, we're not going to see the slides in terms of. There we go. Fantastic. Right, so that's working now. And then and then if you can just drag.
Hang on, but I can't see it.
You have to go over to this.
Wait. Oh, okay. Wait.
There. You got to and then you can cut.
Sorry, technology had me.
Okay.
Okay. Why is it not? Oh, am I?
No,
why am I confused? Okay, there I am.
Okay. All right.
Okay, sorry for that. I promise I'm better with technology. I was having an existential crisis. But starting us off, so I've openly shared some personal data just to get us in the spirit of things, to understand the importance of data. So many of you are using a lot of platforms, be it Facebook, TikTok, Twitter, or perhaps LinkedIn, where you are willingly and freely sharing some of your data. We often say these platforms offer us free use or free access to the platforms, but the truth is you're paying for this platform using your own personal data. So hopefully today we're going to debunk the ideas around data protection, understanding the core terms. I'm going to hand over to Marie, who will delve into data that doesn't fall into the term personal data. So if you allow me, I will swiftly be moving on. So the first thing I want to do before I actually start explaining this practically and in terms of how it applies to everyday life is to just understand the concepts. So when you think about personal data, what type of data qualifies as personal data? It's got to be linked to a specific person. So it's got to be, it's got to identify a living thing, or sometimes it can identify a specific company, so a juristic person. So an example would be if somebody said Zintle in South Africa earns 2,000 Rand a month, that can't be personal data because there's probably like 20 million other Zintle. So it's not personally identifiable or linked to a specific individual. But if you add more context to that information and you say Zintle Novazi, who's a lecturer at Stellenbosch, at this address, that becomes very specific, and then it identifies that specific individual. So some of this personal information can be things like your sex, your gender, where you work, your address. It's information that if it's in the hands of the wrong person, it can be used to do harm, and that's why we look to protect it in terms of POPI. So there's certain types of data. So if the data is encrypted or has been de-identified in the sense that you can't link it, perhaps it's been encoded using a specific number, if I'm able to re-identify that data back and link it to a specific person or specific company, it still then falls in the realm of personal information. But Marie is going to be dealing later on with the data that you can't re-identify or particularly link back to a specific person. So let's look at the term processing personal information. We deal with this term a lot, but what does it actually mean? So this is when you are operating with specific data. It can be different things. So it can be when you collect somebody's personal data, when you decide to store it, when you decide to delete it. All of these activities can be termed as processing personal information, including when we are recording this session. This is Bradley should have actually asked for my consent so that we can record this session, and I would then consent and say, I agree. That falls in terms of processing personal information in that sense. So the important thing now is to look at who are the main actors when we are dealing with data protection. The first person we might want to look at is the data subject. This is a person who the information often relates to. Who's the person whose data we're dealing with? So if we go back to my LinkedIn account, it's got my name, my surname, my employment details. I am the data subject of that information. In South Africa, our legislation is slightly different to the European equivalent, which you may have heard of, which is the GDPR. In our legislation, we include juristic persons. This means that companies are also awarded protection and are recognized as data subjects. So it's not purely limited to human beings. And you might ask then, what is the personal information of a company? It can be its registration number, its residency or place of business. And then the next question you might want to ask is, who is the responsible party? The responsible party can be a public body or a private body. What's very important in determining who is a responsible party, we look to who determines the purpose and the means of processing this data. What I mean is, for instance, if I am running a consulting company where I sell magic notes to students so that they can pass their exams, when I process your data as one of my clients, the means and the purpose would be perhaps the means is that I collect the data over an electronic system that I've created, and the purpose for doing so, for processing that information, is so that later I can get payment for services rendered. So we always look at who's determining the means and the purpose for why that data is being processed, and often that person would be the responsible party. In the EU, the equivalent of that is known as the data controller. So they're exactly the same person. And then you often have an operator. So there's certain circumstances where you might have to outsource a service. So let's think about maybe a Virgin Active. I run a Virgin Active, and perhaps my core skills is making sure that everyone's exercising, the gym equipment is up to date, but perhaps I can't deal with payroll. So all the personal trainers and the instructors need to be paid. So perhaps then I outsource that to an external party to do payroll. That external party who would do payroll would be an operator, in the sense that they are processing information, in this case, information related to payroll, which would include things such as a person's ID, payment information on my behalf. So we would then enter into a contract, and that's how they would be processing that information. So perhaps let's look at this in the context of Strava. So this was taken a couple of years ago, because I'm not willing to share where I stay at the moment. So I was staying in Johannesburg. Not that I'm implying any of you would be interested in stalking me, but it would be nice maybe to know if I have a stalk in the room. So this was a couple of years ago. I was living in Douglasdale. And just based on my Strava activity, a person can see there by the green spot, that's where the activity started and that's where it ended. So if you actually at that point wanted to target me, you know exactly the route that I ran, the time in which I completed. You're able to see per kilometer how fast I run. So if you really wanted to attack me, you need to know, like, this is her current pace, which, by the way, I would outbeat you as based on this data. But the problem with this is that you and I are so free to share our data data on Strava. In fact, with this, I didn't share it, but after this run, I also keenly shared a picture of myself, bragging about my PB. But that information in the hands of the wrong person can put me in harm's way. The person knows where I live. They know the route that I jog. They know what I look like. They also know my age and my activities. So these are things that we need to think about. So perhaps let's apply this in the context of Strava. What would personal information be in terms of Strava? So in your Strava, how many of you are on Strava? So is anyone foreign to the concept of Strava? So Strava is like a Facebook for runners and like anyone who likes to compete. So your personal information there would be any activity that could identify you. To have a Strava profile, you need a name, a surname. Sometimes you can even put your location. So my Strava has that details there. That is personal information. It's easy for a person to identify me based on that. And obviously processing is anything that Strava does with your data. This includes giving you your running stats, even your health information in terms of what your average heart rate and everything is. They need to process that data. And what Strava does is that they allow you to share that information with people within your community. That's also a form of processing because we're now sharing that data. Obviously, with data, the data subject is that person who is doing the activity. So you as a cyclist, as a runner, you are the data subject. And in this case, the responsible party is Strava. They are determining the means and the purpose for processing this personal information. And obviously, in this case, the operator for Strava might be somebody like AWS, because often this information needs to be stored on some form of a cloud system. So maybe they've contracted with AWS to store that data. Okay, so now the question is, we have all these different companies that often come to us and collect the data, but what is giving them the authority to do so? And is it lawful? So there are grounds under POPI, the Protection of Personal Information Act in South Africa, that gives them lawful grounds to process your information. The first prize that everyone goes to is consent, because that's the easiest to obtain from users. So you'll often see like, for instance, this is a very bad example, but it's a good one. In the past, adult entertainment, if you don't need to show hands if you've been on Pornhub or something, but before there was no active consent. It would show the terms. It would say, are you of an age of 18 years and above, and are you aware that this is like an adult entertainment site? Now you actually have to click there. You can check this evening, I won't judge, when it gives you the terms, do you consent, for research purposes? And so you can see how active consent is easy, but the standard of consent is supposed to be that your consent needs to be freely given. It needs to be specific, informed, and unambiguous. So that is the standard that is set in terms of POPI. But I'm going to be looking at other lawful grounds that different companies might rely on. So let's look at the first one, which is basically that it is necessary for the conclusion or performance of a contract. Taking it back to my LinkedIn account, for example, there with LinkedIn, because I know it is an app that can be used to basically help me find a job if I am in the job market. One of the things I have to consent to is to give my employment history, to give details about myself, because otherwise LinkedIn can't go ahead and match me to a potential employer without that information. So it's necessary for the performance of that contract that I enter into with LinkedIn when I use their services. So another one would be, let's see. So then it's necessary to comply with an obligation imposed by the law. So perhaps you might think of your TikTok accounts, your YouTube accounts. So there, sometimes you might be in breach of copyright. And there is an obligation on the platform to actually communicate with the state or certain regulators to say this person is in breach of some of the terms in terms of copyright. So then you agree there that they've got an obligation to comply with imposed legislation on them, whatever that legislation might be. Another one is that it might be necessary to protect your legitimate interests as a data subject. So when we engage in this, there's often a weighing up of the legitimate interests of the responsible party against the data subject. An example of this might have been during COVID. Most of you might be familiar with track and trace. There, often a lot of the safeguards that were available from a data protection aspect were often waived, but that was because it was in your interest that the government had to ensure that you're not in contact with other people and you're not exposed. And that actually also would fall under example for number 4, then that is necessary for the proper performance of a public law duty by a public body. So certain times the government may need to waive certain aspects of processing information because we had this big pandemic that was happening around the world, and we needed to use track and trace to ensure that people aren't exposed. And then we have the last one, which is the legitimate interests of the responsible party. So here I want you to think about Strava. In order for Strava to optimize the services that it offers to you, it might need to give you better recommendations of your route and so on. And so then it allows them to actually collect anonymized data from you and the other people that you're connected to in order to optimize your routes and give you recommendations of new routes to try. So that can be something that is in the legitimate interest. It helps them in terms of being able to give you value in terms of their commercial offering. Okay, so now we're taking a shift. Now that we understand what personal information is, what processing is, what are the parties that are involved, we're going to look at automated decision making. I'm going to explain this in a very simplified way. Most of us, is either that we've been in the market for financial products, or perhaps you are looking for a product online, be it Take-A-Lot or whatever. Most of these companies, what they do is once they've collected your information, they would put you under a specific profile. So let me say I'm applying to Discovery for a new gold credit card. They might decide that the good profile to fit me under is rural and barely making it, just based on the data that I've given them. And maybe some of you are students, so they call you student strugglers. That's the term. And maybe you're a young working professional and you happen to be a parent, and they tag you as tough start, young single parent. Or maybe you're on Take-A-Lot and you're always browsing for glasses. So they go, this one is nearsighted but practically blind. So they categorize you there. And if you're always maybe looking for contraceptives, they will say always almost pregnant. Or if you're always buying things, you could be the impulsive buyer. But all this to say that they create specific categories where they place us in those categories, and then they make certain decisions about us, whether it's what they want to advertise to us, what products they seem fit for us, what the pricing model would look like for you. So are you deserving of a gold credit card versus a black credit card? And often these decisions are made through automated means. This means that there's no human involved in the process. That's why Discovery is able to give you an answer of whether you qualify for credit or not within, I think they say within a day, because if it was a human who had to sit, they'd have to sit with all that paperwork. But now you can have an algorithm and you can set certain terms of how that algorithm will come to that decision. So that's what automated decision in a nutshell is about. The reason why we need to be concerned about this is that it can yield discriminatory results and create extreme unfairness. You can see how on LinkedIn, if there's a certain algorithm that says perhaps this company's always hired Indian men between the ages of 20 and 30, so everyone else is excluded, how that can yield discriminatory results. Or perhaps this company never appoints pregnant women, so it excludes pregnant women from that equation. And even when it comes to access to credit, if you're excluded based on an algorithm that yields discriminatory results, that can have ripple effects on you. So perhaps let's look at POPI, which is Section 71, that regulates automated decision making. This provision is actually just divided into 3 aspects. The first is the prohibition against automated decision making, or it's your right not to be subjected to automated decision making. And then there's exceptions to that. So it's not an outright right that doesn't have exceptions to it. It's supposed to have a balance. And in the event that you have been subjected to this and your responsible party meets one of the exceptions, there are appropriate measures that are being put in place to protect you. So quickly, I'm only going to read the sections that I need to break down to you, but basically in terms of section 71, subsection 2, it says a data subject may not be subjected to a decision which results in legal consequences for him or her, or which affects him or her to a substantial degree, which is based solely on the basis of the automated processing of personal information intended to profile of such person, including his or her performance at work. These are just examples: creditworthiness, reliability, location, health, etc. Okay, so let's break that down. Automated decision making, the prohibition itself, meaning you're not allowed to be subjected to this, only applies to solely automated processing. Now, this sounds great, but it's actually problematic, because if I'm a responsible party and I want to make more automated decisions, to fall out of this provision, all I need is a human to interrupt the process. So what a lot of companies are doing is they would get an AI to make the decision. So it says Zintle is applying for credit. She's Black and lives in this area, and therefore we don't think we should award credit. And that decision is automated. No human looks at it and says, oh, but we live in South Africa, in the context, and puts that aspect into the equation. And so then I'm denied credit. But the problem is, if I just get a clerk at the end of the day to rubber stamp the decision made by AI, I fall out of this provision, which means I don't need to abide by this. So that's why it's problematic in that aspect. The second part, it says these decisions must have legal consequences or affect the data subject to a substantial degree. This seems great, because then it's quite inclusive. It means like things like when you're applying for credit, when you're asking insurance companies to generate quotes for you, these can be things that fit into this category. So we're trying to protect against decisions that would truly affect you. The only thing I have a problem with this is, how do we determine what affects you to a substantial degree? To this day, there's no determination in terms of Poppy whether this is an objective test or a subjective test, because maybe not getting an appointment at Sorbet to do my toenails, it would affect me to a substantial degree. But for somebody else, that could be something completely different, where it's access to credit or it's access to housing. So we need to have a scale. So that's something the information regulator needs to deal with. The question then is, what are the appropriate measures? So let's imagine for a second you apply to Discovery. You apply to any bank, Capitec, for access to financing. You want to go and buy a car, and now they've denied you this loan because apparently your credit score is too low. And this whole decision was automated. What are the remedies that you can have in terms of Poppy? So in terms of the subsection 3 of 71, there's two options. I want to divide them into a broad aspect of it, which I think would give more remedies, versus the narrow. So if we start with the broad aspect, if you want to challenge a decision that is purely automated, you need information about how the person came about that decision. And when they're going to automate a decision about you, you need to be notified at that point in time so that you know. So if we look at this inclusively, Section 16 of Poppy speaks about the quality of the information, meaning that in terms of Section 16, there's an obligation on the responsible party to make sure that the information they collect about you is actually up to date, it is accurate. And this will help, because if you want to challenge the decision, you can say, in terms of Section 16, I hope that when you made the decision, you're making it on the basis of accurate information. The other thing is that there's an obligation in terms of Section 16. So in terms of Section 17, then there's an obligation that they keep the documentation that they use to process specific information about you. And this is good, because if you want to go back and say, but give me the documents that you use to make this decision, then you can request those documents. And lastly is the notification right, which is in terms of Section 18 of Poppy. This is the idea that whenever somebody processes information about you, they need to notify you. And this is important, because otherwise you don't know at what point this person was making the decision, because then that gives you the right to object there and then say, this is an automated decision, I need more information, or I'm not happy. You can object at that point. The narrow approach to looking at the remedies would be that you would just look at what's written under section 71(3)(b), which basically says the appropriate measures is that you must be given the underlying logic of how that decision was made so that it can assist you to make representations if you want to challenge that decision. But it's still undefined whether the underlying logic of a decision would include things like the actual algorithm. Can I ask for the mathematical formula that was used to make a decision about me? Or is this simply a reason that is high level and includes the rationale? So let's say you are looking for an explanation in terms of how this decision was made. What type of explanation can you get? I would basically summarize these explanations into two, but they're kind of like four. So the first explanation you can ask for is an ex ante explanation. An ex ante explanation would be an explanation before the decision was made. But this is limited because if I'm going to ask for an explanation before the decision was made, it can only be a system functionality decision. This means that you can tell me that factors A and B were incorporated to equal C. You can't tell me about the rationale because this is obviously before the decision was made. The second type of decision I can request is an ex post decision. This is after the decision was made. And the nice part about this is that the responsible party could then combine a system functionality reasoning as well as give you a specific decision. So they can say, this is how algorithm makes decisions. It factors points A, B, and C to reach point D. But the rationale that was applied is these specific pointers, and that's why you were denied credit. So in the second aspect, I think it's more of an inclusive thing. But now the issue has become that when we ask for an explanation, there seems to be a concern that this infringes trade secrets. Because if you think about it, if I'm going to ask a bank or an insurance company to expose the mathematical formula to how this decision was made, in essence, they need to expose their trade secret. That is the root of what they use to be competitive in the market. So the question is then, how do you balance this? Because you as data subjects require a certain degree of transparency so that you can be able to challenge decisions, but we also need to balance the trade secret sort of requirements. But coming back to that, there is a way to strike a balance. So what we're seeing in the courts in Europe is that there are processes that can be put in place to ensure that certain algorithms are audited. Or in certain cases, the judge can be the person who then looks at the specific mathematical formula to see if there are certain biases that can be taken care of to ensure that the data subject is protected. So the equivalent provision of Section 71 of POPI is also available in the GDPR under Article 22. So here, the main reason why I'm just bringing this up is that unlike POPI, this has a direct right to get the data subject to require human intervention. So if you had somebody automate a decision about you, then you would be entitled to say, okay, at this point, I want a human to consider this decision. And the EU has been very advanced because they also set levels in terms of the qualification and the degree of knowledge that that person must have. So it can't just be a clerk. It would have to be somebody who can exercise a certain degree of command within that specific enterprise. So that's just to guarantee extra protection. Okay, I'm not going to have time to run through all of this, but ideally, and this also sort of works out in the South African case if you wanted to play it out. So if Discovery has made an automated decision about me to decide how much I must pay on my insurance premium, and it's gone up from 800 to 1,500, and it's purely automated, the question I would ask, can my personal data be processed by Discovery in a solely automated, or for purposes of yielding a solely automated decision? If the answer to that question is no, then I've got a right not to be subjected to an automated decision. But if the answer is yes, then there has to be a legal basis upon which they're relying on, whether it's because of contractual reason or it's guaranteed in terms of the law. There's a specific provision that they are relying on, maybe in one of the insurance acts. And then, yeah, you can basically follow that. So let's say it's yes for contractual reason because I want to be insured. Then they would say, yes, it's necessary for entering into a contract. And then basically in the EU, those would be the different rights I would have that are associated to that. So I'd have the right to have a human intervention, or I'd have the opportunity to express my viewpoint. So that's something that can be played out. But the big question is, do you actually have a right to explanation? So in terms of POPI, as it stands, there's no explicit right to explanation, but it can be inferred in other provisions. And the fact that our Data Protection Act tries to guarantee transparency, or transparency is one of the principles that we abide by, you can indirectly infer it, but there's no explicit right to explanation. The GDPR in the EU, they're having the same issue because the right to explanation exists in the recitals. The recitals are basically, you have the EU articles, which is the act, and the recitals explain what the act is saying. So the recitals are not binding, they're actually just there for interpretation's sake. But when you actually read the provision itself, there's no direct right to explanation. So the EU is also in this position where they have to either indirectly infer this right to explanation. So we're not the only ones in that position. And if we look at case law, and I'm specifically looking at EU case law, because in South Africa, we don't have any cases yet on ADM. We had the Schufa case that happened in Germany, basically, where this German man was denied access to credit because his Schufa score was very low. And he wanted an explanation to understand how they came about to generating that score. So then the courts there confirmed that if you're going to use ADM to generate a credit score in order to determine whether somebody can apply for credit with a bank, that would be a form of ADM, so automated decision making. And then we had a later case that was decided earlier this year, which is the Dun and Bradstreet case, where the man here was denied an opportunity to enter into a cell phone contract on the basis that, again, his credit score was too low. But here of interest is that the judges had to determine whether the algorithm could be exposed so that the person could understand how that decision was reached. And the judges actually said that it doesn't help to expose the algorithm because your average person will not understand. What the person needs is the rationale behind the decision. But again, this is debatable. Okay, we looked at the AI Act last week, and the funny part here is here for the first time now, you've actually got a direct provision that actually provides a right to explanation, but only in terms of high risk, excuse me for a second. Yeah, in terms of high risk AIs. So if you just look, it says this article states if a decision is made about a person using high risk AI, and that decision has a significant impact on the person's health, safety, or basic right, then you've got the right to a clear explanation of how that AI system was involved in the decision-making process. So again, you're seeing resemblance of the original provision that they've kind of highlighted areas that would affect you to a significant degree. And so if a high-risk AI is used to make an automated decision about you, you would be entitled to a decision in terms of the AI Act. Excuse me for a second. Okay, and then moving on to my last slide before I hand over to my dearest colleague. So here, what I just wanted to point out is that the provisions under Article 86 of the AI Act, if you want to look at it. So it does offer a right to explanation, as I said. But what is interesting here is that it's left to the data subject, if I can put it that way, or the individual who is affected to determine whether or not they've been significantly affected. So we can see this is more of a subjective leniency, and it actually specifically stipulates that there must be a clear and meaningful explanation. Whether that means exposing an algorithm or explaining the logic, that's yet to be seen when it plays out in the courts. And when we say the decision, remember we're speaking about specifically the decision that was taken by the deployer of the AI. You guys would have, you went through the terms last week, so you would know what a deployer of the AI is. And so that brings me to the end. What I have not covered now is data that does not meet the requirements of being categorized as personal data and what that looks like. And that's where I'm going to hand over to Marie.
I just want to clap.
Sorry.
Thank you so much. That was really a masterclass in getting information out to me in a very short period of time.
Thank you.
Take a commercial
Yeah.
break.
Yeah.
Do you guys have any questions about today's presentation while we switch over? Because it was a lot of info. So if you would like.
Just a comment.
Yes.
A footnote
Okay.
that usually means a long time. Given all that we've been learning about how AI works,
Mm.
I very much doubt that it's going to be a useful endeavor to open the books at a technical level.
Yeah.
You would invariably need a logical explanation of what is happening behind the curtain.
Yeah.
And there would have to be a level of trust there because you wouldn't know how the view works.
Exactly.
So there would have to be on affidavit, presumably some explanation of what it's doing.
Yeah. What?
But not at a technical level. It doesn't. I don't see that serving any purpose because, as Charlotte explained,
Yeah.
in the heart of all this data about data,
Yeah.
it's a dark place.
That's true. There's lots of black boxes, but I think that's going to shift. So maybe for the average user, the data subject themselves, you and I, the technical part is not important, but I think on a bigger scale, it will be good for transparency and holding certain companies accountable. So what I'm seeing now in the EU with their Consumer Credit Directive 2, they've now infused the GDPR and the AI Act. So I think they're going to try and create room for audits, which might be done by the supervising authority, which is the equivalent of our information regulator. So then that would be the person who would audit. And then it protects the trade secret, but then you still have some form of transparency and accountability to hold these institutions into account. Because I think the other problem is the reason why they don't want to expose the mathematical formulas. Lo and behold, everyone actually knows how to improve their credit score. So everyone then gets high credit, because it's not just the fact that they're only taking into account when it comes to deciding whether you are going to get a loan or not. They're not just looking at your employment and your payment histories. There's some research, I don't know whether it holds ground, that some people are looking at your own online data to make assumptions, which is then added to your credit score. Things like who are you linked with on Facebook, and what are certain assumptions we can make about the groups that you hang around and how they might influence your spending habits. So if that data is taken into account to determine my credit score, I should be able to know so that I can unfriend all those people that are bringing down my credit score.
The other thing is the algo might be 100%.
Yeah.
The training data
That's the other
might be perpetuating a bias.
That's also true. But then that's where the audits would come in, because then we know that the issue is not with the algorithm, then we need to fix that. But now if no one knows who can externally hold people into account, how do we fix that problem?
But so in Popia's right,
Yeah.
I would say that you would be able to ask what training data went into the one side of it.
Okay.
Surely.
Yeah.
I would
Yeah.
think so.
I think if it plays in the courts, I think you're right. Definitely.
Yeah.
Yeah.
And then if they say, well, we looked at people that live where you grew up,
Yeah.
and they're all very bad with credit.
Yeah. Then you
Then
got.
juicy case.
Yeah. Because also it's like, how do you then contest the decision if you also don't understand technically what went into it? Because the rationale is good, but then I need to know, okay, it's like somebody explaining maths to you, but not showing you that they use bod maths to get to that answer. So then I can say, fine, the answer is wrong. It should not be 8. It should not be 9. But then you go, the logic is, oh, you used the wrong maths equation. But then tell me what the equation, tell me bod maths was used so that I can go back and be, okay, brackets are, I don't fuck with bod maths. Sorry.
Yeah, I wanted to ask, because obviously the big issue is that in AI, there's a lot of talk about how do you solve this, like all the harms that can do with AI.
Yeah.
And then they say, well, you just have to have a human in the loop.
Yeah.
And that seems like the gold standard, like this is how it's going to fit. But then obviously with the rubber stamping issue, is that this human in the loop approach is actually harmful.
Yeah.
Because it's meaning that all these things that should be more carefully, like underneath Section 71, is just excluded.
Actually,
So
yeah.
I was going to say that surely that can't be, it can't be that it just allows rubber stamp.
Yeah.
But from my knowledge, it's so, all of us are never going to challenge the decision because who are we? We're just individuals who, I don't know, you applied for a job and they automatically assessed you on those psychometric tests, used all your information, then declined you. So you're not going to test it yourself.
You should. I think people are challenging it more and more. And coming back to your rubber stamp decision, I think that's what the EU saw. And that's why they've now set terms to say if you are going to have human intervention, we require a certain degree of knowledge and also authority in that space. So it cannot be a clerk so that we go, oh, the clerk didn't know. It actually has to be somebody who's with a certain level of seniority. So I think that will help in a sense. But also in terms of challenging, I think you take it for granted, but you do. Like sometimes an insurance, I know I did with Discovery, they're like, oh, your insurance premium is like 1,200. Then I was like, okay, I don't want it. I'm going to My Way. Then you put up what My Way gives you against Discovery. So can you top up what My Way says? So in a sense, you are challenging it. You might not be using the mechanisms, but you're saying, I'm not happy with how you got to that decision. And you can also ask, like, why all of a sudden, if I've moved from Stellenbosch to Somerset West, is my premium increase? And they will tell you, like, okay, Somerset West has this and this, and that's what's. So they do tend to give you a more logical explanation. But I'm also going to ask Derek if you want to pitch into that answer. It will be nice to have someone.
That's a good question. The solely is problematic.
Yeah.
Because it's so easy to tap out of that.
Yeah.
You just have a person there. Yes.
Yeah.
It has to be more substantive, and the legislation is written in a way that makes it difficult for a court to help you. I think, because solely means solely.
That's true.
Yeah. Sorry, the GDPR version is significantly better.
Yeah.
But even so, not beyond
No.
manipulation.
Yeah.
So a fair point. I don't think human cures it.
Yeah.
But it's all we have.
Yeah. And also, GDPR, it's not yet in the legislation. So this was guidance that was given by the European Data Protection Board. And so there are more recommendations. They're technically not binding. So that could also be problematic because then you're not forced to follow what they say.
What's the point of the recommendations then?
It's industry.
Well, the court might take it into account when ruling on a matter, so it has persuasive power.
Yeah.
Yeah. I mean, the other challenge is that often there are downstream decisions that are made. That's earlier a client or a process, an ADM process could have taken place, and then this could change its hands through a variety of different third parties who've purchased the credit information detail about that individual.
That's an excellent point. We had a thing just like that today where these things are clustered together.
Yeah.
So it's a little naive to think it's just one bot.
Yeah.
It might be speaking, especially with the agentic thing, to 50 others.
Yeah. Then how do you challenge that?
So you have to really want to do it.
Potentially only a class action suit that's finished.
Sorry, two things. Sorry, I know Ms. Lowe probably wants to get to her part. Do you not think the Poppy Act is outdated, considering the advancements both in AI itself, but also now understanding of AI since the Poppy Act was created?
Yeah.
But also in terms of these automated decision making, how does one determine that they aren't excluding important information? Because you talked about including biased information. But what if they're not including things like disability or previous disadvantage or that sort of thing?
Okay, so but Derek, also feel free to jump in. I think it also depends what approach a specific country takes to how it legislates. So you get the EU that gets antsy and it was like, oh, something technology is happening, new legislation. But I think the approach that we have taken in South Africa is a constructive one where it's not to over legislate, but look at our existing laws, because even if they're written in the context of 20 years ago, they can be interpreted to meet the needs of now. So I also don't think Poppy is necessarily out of date. What the problem with Poppy now is we don't have enough interpretation coming through the court. So we need to push more cases through Poppy, because that's how you get interpretation of the different provisions. But it's also how you actually, in a sense, get to make law and make it adapt to the Bone Morris of society for today. And then in terms of your second part, in terms of inclusivity, so that's where transparency comes in. And we need to go back to trying to figure out how do we hold companies, responsible parties, particularly, or deployers of AI into account. So maybe being transparent and having, for instance, if I had to put it in South African terms, say the information regulator should be the one who's responsible to do audits on specific AIs to see if they meet those requirements. And even if they fail to take into account important things like gender, race, and all of that, we still have the Constitution to put that into account. And if it's discriminatory, you can go all the way down to Papuda. Yes, I'm sorry, my public law brain doesn't mechanisms in the law that you can use, but I think a lot of it will be dealt with if we can just push more into the courts. But I think also Derek.
And the regulator is getting better. I think they took a while to sort of build capacity, but we have matters in our business where when there's a complaint, it gets actioned, and you can see the person on the other side knows what they're doing. So I expect few data subjects will take on the discoveries of the world. Yeah. But if a complaint is laid against them with the regulator, that mechanism is I think getting underway. That administrative remedy is really effectual, and we've had to do some fancy footwork because they asked the right question. So I think they will give effect to what the legislature meant there.
If you look at some of the more recent statements that have been issued by the information regulator, they've been quite open about the fact that they want to put something down and then have it get challenged. So I mean, they've already been quite vocal about them not thinking about the provisions around direct marketing in terms of their reading. It should apply to telephone calls. That's come out now. In terms of papaya, it should not. But they are willing to put it out there so that they can get contestation and clarification in the court. So I think with an active information regulator, there's still a lot of space there as well. I mean, it should necessary given that this.
You're right. I mean, they put things out there. They sometimes take a whipping. But that's what I mean. We really like this, but we don't like this. I mean, this is 1980s. But that's how you, I think, develop good frameworks.
It's all good democracy.
Exactly. It's a mundo.
Okay, thank you all. So I'm going to turn the camera back to Marina and zoom out, but you are welcome. my high-tech panning. But anyway, you are welcome to go ahead.
So guys, just before I start, I have one anecdote. When you showed us your Strava data, it reminded me of a war story that we have where this sounds really extreme, but so this is real. In e-commerce, targeted advertising has become so invasive that they scrape publicly available data on Strava that you post. And from that, they can calculate how long since when you last bought a pair of tackies from them. They should start hunting you with advertising for another tacky based on how many kilometers you've run. And they know that the tacky that you bought has an average mileage of this many kilometers. So it's really that hectic.
I haven't received any notifications. Just putting it out for you.
Lifetime jacket.
I thought I'd put out sufficient kilometers onto that first pair, but anyway.
You guys are saving money, don't worry. Okay, so just to give you a bit of context of where we are now, we've now learned about what the regulation is of personal information when it applies. And if you have your lawyer hats on, you may have been thinking to yourselves, well, is there an escape hatch? Is there a way that you could advise a company to allow them to reduce their compliance burden? Before we get into that, just a bit of recent news that just shows that data privacy legislation is an obstacle to the development of AI models. In this case, in my view, for the better. And this is also a bit of background of the opinion that we'll be discussing on anonymization of data and AI models. So Meta decided that they want to train their AI on your Instagram and your Facebook posts, which is really scary, but it is already happening. They quietly announced this and put a really convoluted opt-out mechanism. The EU regulators sounded the alarm bells and basically warned that this would be unlawful. because of this, Meta paused the rollout of these changes to its privacy policy for EU citizens. And following that, that caused some uncertainty, which led to the adoption of this opinion. Meta went and read this opinion and said, cool, thank you, we always complied. And now they are rolling out their program regardless. And they put out a really dystopian public notice basically saying EU citizens get pumped. We're going to process specifically EU style for you. So that's basically what's happening at the moment. So tying into that, that was the impetus basically for this opinion. This opinion was published by the European Data Protection Board, which we've discussed a little bit now. In the EU, they have a piece of legislation called GDPR, which Sinclair's told you a bit about. It's quite similar to POPI for purposes of the level of depth that we'll go into here. You can take what you've learned about POPI and apply it pretty much equally just for purposes of this. There are similar lawful bases, etc. But this Data Protection Board essentially publishes opinions at the request of country-specific supervisory authorities to ensure that GDPR is enforced uniformly throughout the EU. So although they are non-binding, as we've discussed, they have a lot of persuasive force, especially on issues like this, where regulators don't know what to do and they don't want to make the wrong decisions. And often they become law through subsequent rulings. So to give you an idea of what we're going to be talking about and why it matters, as we've now learned, GDPR applies to information about natural persons from which they can be identified or from which they're identifiable. So if information is truly anonymized, to the extent that it's anonymized, GDPR does not apply. And the same follows for POPI. We have a very similar definition of personal information, save that we include juristic persons. So if you can anonymize, it no longer applies to that extent. This opinion specifically, however, limits its scope to models, AI models, not AI systems. So the underlying core algorithms that we use to train the systems, but without a user interface. So you can't interact with it. So a model would be GPT-4 and the system would be ChatGPT that you talk to when you're lonely. And then the scope of the discussion focuses on models that were trained on personal data. So that's a given. We're not talking about a situation where a model was entirely anonymized from the start. It never touched personal information. That is technically impossible at this stage. And we are also not talking about models that intentionally display personal information. So that is basically how we're framing this. The question of whether you can derive personal information from the output of an AI model is similar to asking, can you unscramble the egg? Except in the sense that in real life, you can't unscramble an egg, but we've shown that for AI models specifically, you can, to a limited extent, unscramble the egg if you have the expertise.
Disturbing egg.
Yeah, disturbing egg. I generated this image purely to make you guys uncomfortable. That was my aim for the evening.
It gets worse.
Yeah, Bradley can see the preview. And you'll see what I mean, but I don't think he likes my taste in music. But let's start with just some terminology here. So when we talk about anonymization as a goal, it's distinct from pseudonymization in the sense that information can be re-identified after it's been pseudonymized if you have the authority or a key to unlock it, basically, in simple terms. Whereas with anonymization, it is permanently and irreversibly anonymized. Nobody, not even someone with authority, can roll that back. So that's essentially the aim if you want to escape the application of GDPR. But let's take a model like ChatGPT and assume that it doesn't display, or it's been programmed not to display personal information. How would you be able to tease out personal information that was in its data set? So the opinion refers to this academic article that talks about membership inference and model inversion attacks. So a membership inference attack would be where you query the model iteratively to try to find out whether a specific individual is part of its training data set. So yeah, let's say I want to find out whether I'm part of a training data set of a hospital, and I keep asking it questions, and the response would essentially be yes or no. So it's not going to give you more information about me other than that I'm part of that training data set. Then we go to model inversion attacks, and that attempts to expose an actual reconstruction of me in the original training data set. So in that sense, if you get an AI model if you succeed in a model inversion attack, you will actually learn something about me. You will gain additional personal information beyond a yes or no answer to whether I'm part of that training data set. So this is where it actually gets spicy for the nerds. There was a lot of academic speculation about how we would treat the question of anonymization. And it's actually quite a nuanced one, because you can think to yourself, hypothetically, the question whether it is technically possible in today's world to extract personal information from a model is different to whether that's reasonably likely. Reasonably likely is a far more objective criterion. So this opinion went in the reasonable likelihood scenario, and that's with reference to two kind of common sense criteria, which are who has access to the model. So it's different for a model to be deployed publicly to anybody who has internet and a PC versus to, let's say, an office of 10 people who use it internally. The likelihood of an attack or the incentive for an attack would be way higher if anyone can use it. And then the second criteria would be the technical means that are available to individuals to launch an attack. And just like companies need to continually update their security practices as hackers become smarter and technology evolves, in the same way, what could be considered anonymous today might not be considered anonymous tomorrow with advances in computing power and clever people and technology. So because it's really hard to lay down hard and fast rules, the opinion has not attempted to do this. It essentially shifts the responsibility onto the providers and developers, or in this case, responsible parties of an AI model, to prove that their model is anonymous and not the other way around. This would require you to maintain documentation continuously, and you don't prove it once and then you're scot-free. You need to keep proving it, because these things obviously train continuously, and there are always opportunities to absorb new data from interactions as well. So you need to continuously prove that it's anonymous. And again, it's a case-by-case evaluation. So they won't class a certain group of AI models. They'll look at each of them on their own merits. So a bit of practical application, I decided to put on my hacker hat and try to hack ChatGPT. It was not very difficult. So here's my first membership inference attack on the left. We have got Bob Dylan in the style of Pablo Picasso. This was my little membership inference attack. I just want to know, yes or no, is Bob Dylan part of ChatGPT's training data set? Judging by his iconic suede jacket and those tufty curls, whatever you would describe them as, he's definitely part of the training data set in my view. In the middle one, we've got a Salvador Dali-esque Dylan. At this point, I can see some more characteristics of his physical features. It's really clear to me now that he's in the training data set. I've succeeded with my membership inference attack. And on the right, I asked it to generate a hyper-realistic image of him. For those of you that have only seen the movie, you might be disappointed that he doesn't look like Timothée Chalamet. And I decided to spare you by asking for an image in the 70s, not what he currently looks like. But this is all just really to say that ChatGPT, while it has privacy limitations, it's not designed to be completely anonymized. And this is essentially from what I've observed from my own interactions with it on a sliding scale, which is also quite intuitive because there's a lot more training data about Bob Dylan that it has absorbed than there is about you or me. So at least insofar as celebrities and public figures are concerned, it's not feasible to anonymize an AI model, really, and I don't think that you would actually want to. Taking it a bit further, getting more personal with some political views, I asked it about Bob Dylan's stance on segregation in the US in the 60s, and it gave me a pretty well-versed example. Political views in South Africa and in the EU are a category of personal information called special personal information, and it's regulated at a higher standard with a higher compliance obligation. The exception is if you've deliberately made it public. So Bob Dylan's deliberately told us all what he thinks through his songs, and thank him for that. So he can't launch an attack that his consent was personally required to process this. But would you think differently if these were your political views? If you had perhaps posted something on LinkedIn at some stage, maybe when the VAT increase was announced, you got really mad and in a moment of passion, you let everyone know what you thought. What would you think if I could search that about you and get that information? Well, this is where it gets creepy. Yeah. So what we've discovered through our own, yeah, I know because you posted it, so I picked that one. Yeah, so if you wanted to get creepy, if you wanted to do a bit of sleuthing,
Good grief.
I asked ChatGPT where Derek's going to be tonight, and it promptly told me that based on SWAT attorney's posting about this event, he will likely be attending, although he has not officially, confirmed his attendance. It made a bit of an inference there. So the rest of the chat isn't here, but I try to ask ChatGPT what Derek thinks about South African politics, American politics. I already know, so I would be like a decent person to calibrate the accuracy of that. And it had a really measured and careful response. Derek's posted a bit about what he thinks about tech innovation and doing that ethically, but he hasn't shared too much about his personal political beliefs, at least on LinkedIn. So, yeah. And interestingly, it draws the privacy line somewhat arbitrarily, in my opinion. So it will tell me where Derek's going to be tonight, but I asked it to make a cartoon of him from publicly available photos, and it vetoed that. It refused to. Maybe luckily for my job. But you can see that it is grappling with that gradient of how publicly known are you, what expectation of privacy do you have, what information could I share about you, and what information might you consider offensive. It's maybe not a legal standard, but it seems that they grapple with this in a way that's less likely to get them in hot water from a media controversy perspective. So you've learned a bit more about the lawful basis for processing, and what I've copied here at the bottom is the most important lawful basis for processing in the world for AI today. That's from section 11.1f of POPI, and it's the only potential legitimate basis, or lawful basis rather, for developers and deployers of large language models to reasonably rely on. They can't really rely on, because of the
No, it's fine. I'm thinking.
I also meant to say that I'm just going to work this into the Q&A session as well. So if anyone has questions or wants to interrupt me, you are very welcome to. But so the rest of the opinion that I haven't discussed in depth here talks about legitimate interests, and Facebook's interpretation of what they said about that led them to believe that they could go into the EU and scrape all of their EU Instagram and Facebook users' data as well. It is a three-step test to analyze that I won't go into now, but suffice to say that in EU law and in South African law equally, it involves a balancing of rights. So it's similar to our section 36 rights limitation analysis, where you look at what your interest is what you're doing necessary for that purpose, and then balance that against the rights that you're infringing of natural persons.
So is profitability legitimate interest?
It could be.
There are some, There are some signs that a purely commercial interest can be a legitimate interest from EU case law, but we don't have a definite answer for that yet.
That's the mess.
Yeah, but this is essentially what it will come down to. And taking that a little bit further, so if you want to live in a world where ChatGPT can't use your LinkedIn profile and allow your stalker to find out where you are tonight or show you photos of Bob Dylan, hypothetically, what we could use to make an LLM like that is synthetic data. Synthetic data is something that LLM companies are currently using, but not for data privacy reasons due to scarcity. So Llama, Pi4, and ChatGPT are already partially trained on synthetic data. And synthetic data is essentially data that is supposed to mimic the attributes and behavior of real data, and it was originally derived from real data, but there's no personal information in it anymore. Incidentally, again, companies seem to be less concerned by that and more concerned about remaining competitive, as you can see Elon Musk has commented on. Yeah, but there are estimates. See, Derek just made a face, and now we can all observe his political views. But yeah, real academics estimate that we'll run out of real data to train AI on in 1 to 5 years. But this is, in my view, and I'm not an expert, a thumb suck, because we don't know how quickly we'll develop computing capacity to accelerate the development of these models either. So yeah, there are pros and cons of this. I mean, hypothetically, I guess if you wanted to create a smaller model that's used in a limited context and you need good quality data that doesn't implicate personal information, perhaps also for privacy reasons, because you have a service provider that maybe wants to generate reports for you, but you don't want to share your real company data. You want something that behaves similarly, then you could use synthetic data in that context. But for models like ChatGPT, from the bit that I've read, it seems like there is a risk of model collapse through essentially the model losing touch with outliers that would affect its training. So if you're just regurgitating like a generalization, then you can see that the thing would become pretty narrow-sighted. And in any event, it's apparently not technically feasible for it to be a complete solution ever. We will need to continue using real data. But I suppose the bigger question is, with all of us using ChatGPT and other LLMs, I clearly have a favorite, but with all of us using these models so extensively to produce content I mean, I don't know if you get those reels about all the hustles you can do with AI. Clearly, my algorithm thinks I need a job, but there will be so much synthetic data in a sense that we've derived it from online and put it back into the real data scope of the internet, that essentially I think that either way we are going to be seeing LLMs that are trained on synthetic data that we've published, and we'll lose that line between what's real and what's synthetic. On that very dark note, thank you very much.
Thank you. I'm mindful of time, being the day before May Day, but that was very interesting. Are there any questions, any comments from the floor? I mean,
Feelings.
Yeah, this blurring of lines between synthetic data and real data. I've suddenly was sitting here wondering whether or not AI has already scraped our learning management system. I hope not. In the background, I mean, where's all of that information being stored? Go ahead.
I have personally like an ethical issue with AI being trained and scraping copyrighted information, like specifically published books.
You have a friend over there.
Thank you. But then also with being trained on incorrect data. So like I have a very like personal example. I discovered also from TikTok that you can use ChatGPT to generate information on a person, because I'm a bit stupid, I didn't know this. And so the first thing I searched was, so the first thing I searched was my dad, because he has a Wikipedia page and I happen to know some of the information on there is incorrect. So I was curious as to whether it would use that or whether it would use the correct information from other platforms, and it actually used the incorrect information. So that to me also presents like an ethical issue when they're then presenting that data to users. And obviously they give the caveat that, you know, it's potentially incorrect. But when it's being used for a lot of people as like an educational tool, I think like there should be a higher burden on the training side of things.
I agree with you there. The copyright aspect is a separate one, but also very troublesome and ethically concerning, and also leads to an issue where I think you'll see that regurgitation that we were talking about. For the incorrect training data, like conceptually, is it what bothers you that the computer is dishing it up and it's not a human that may just not have had the right information?
Yeah, like to me it's kind of like if you find a word in a dictionary, it should be correct. Whereas if I ask you the definition of a word and you don't know, that's less problematic to me because you're not kind of presenting it in a format where it could potentially be conceived to be coming from someone who has that expertise.
It's the misleading aspect, and that's what's also so concerning to me about the fact that Google has introduced that AI summary.
Terrible.
I hate that thing, and I love it sometimes, but
The law was not with that as well.
I mostly hate that thing because it gives you a quick answer, and if you don't go onto that source yourself, like I'm trying to research my telecom contract, but it's giving me info from NTN, and then I get excited, but I'm not with NTN. But so that's just a good example of the fact that we have a bias towards thinking that information dished up to us by technology is somehow more objective and fact-checked. But it's actually not the case. If you read Wikipedia, it's so well known to all of us because Bradley's been telling you since your first day. Wikipedia is reliable and they don't know anything. So when I read Wikipedia to this day, I have Bradley's voice in my head, and I don't take it as the complete truth.
That's the starting point.
A very angry brain. But we don't have that same voice in our heads, or a lot of us don't when you use ChatGPT.
Not the onus be on us though. It's like there's lawyers that go get case law, and then they put, well, it's almost like made believe case law because there might not actually be any case there that relates to the specific fact. But then we put it in legal arguments and submit that to a judge. You can't really blame ChatGPT.
But like if you're paying for the more advanced version,
even if I'm
paying for a service, I expect it to be delivered at a higher level.
Well, in that case, you pay for a custom service, right? So then you pay for an LLM that's been fine tuned to your specific context. So if you're asking it a legal question, there would be a human who would have been the expert there, fine tuning the algo and correcting it as it makes mistakes and using prompts to teach it. So it would just be where you find the service. So obviously ChatGPT is not an expert and not a judge and not a lawyer. So we shouldn't rely on that at all. But where we can fine tune an LLM or a smaller LLM for our specific context, that might be a lot more credible.
But
And also sorry, Pepper.
I was going to say, as the end user, the responsibility is still on you because even if I had to consult for services with a law firm, I can't just be like, okay, I've consulted their services, so everything that they say, I still need to sit and go through it and go, is this the legal advice that I asked you? So that duty is on me. Even same with products that you buy. When you go to Woolworths, you expect that nothing on the shelf is expired, but that it's still your responsibility to check the expiry date and then be like, actually, this is expired. So that
give it to me.
You can't just drink it like it's Woolworths. It has to be top quality because I'm paying for the service. You will then have to return the product, and that's when. So I think the same thing applies to using Gen AI or LLMs.
But on that topic, like you brought up such an important concern really about reinforcing untruths, although actually they're not lies, they're just not true. It's through the process. Well,
thank you, Donald.
See, the computer is different. But like one example of this that I actually found out about through researching one of our previous talks was a lot of people in the West, even in academic circles, believe that China has a really widespread social credit policy where they rank you up and down in points. And to an extent, that is true. That's not really the point. The point is that the ACLU, like a reputable research organization, published a paper about China's social credit scoring system after the Chinese Communist Party put out a notice saying that they're implementing this new regime. But it was in Chinese and CCP speak, which is difficult to translate to what they really mean. So there's a lot that's kind of lost in between the lines there. And this article referenced only that and basically thumbs up. So it was not accurate. It wasn't a specific policy, but this was picked up by major news organizations, think like Washington Post, New York Times. Now everybody's talking about how evil China is, like demeriting people for smoking and for 10 points up for running, and then you get housing based on that. So that's just the snowball of something that people trust for right or for wrong, creating truth. And to this day, if you go and search China's social credit system, you will find a lot of reputable articles telling you that it works exactly like that. And you need to go watch a YouTube video for 10 minutes to find out that this is why. And with AI, that's already happening on a scale we cannot comprehend. And it's the first thing that I thought of when this all became real is what's going to happen to truth.
Yeah.
But then how do you as a researcher, like we've got lecturers who are writing papers and they're writing journal articles, do you then have to rely on like primary sources only? Like what?
So as an example, you would pay for journal articles. Well,
Most of them.
yeah, no,
You
you would
should
pay for
come in
journal.
at this point.
Yeah, I use ChatGPT extensively. I didn't even know how
We
to
wondered whether she was perhaps a cyborg.
I'm starting to think like it. I confessed to Derek the other day for a few glasses of wine that I'm concerned of using it too much. So like, I'm really not one to be all holy about how you shouldn't use ChatGPT.
Don't use it. I can see when you've used it in your subject. No, I'm not saying don't use it. I'm saying don't use it until you've got enough level of knowledge to challenge the knowledge that it spews at you.
Yeah.
You need to first have your grounding. What's really fun is when you challenge ChatGPT's answer and you're speaking nonsense. I know based on this provision, and then you have that chat. But if you don't have enough knowledge, you can't challenge it. And then worst of all, if I call you in and say, okay, you drafted this wonderful piece, explain to me. And then I said, explain, you speak about this author in paragraph 2. You don't have the process to understand at what point ChatGPT incorporated that or what was the thinking. So there's magic that happens when you actually research and you sit with the data and you figure out what argument you want to come through your essay. If you get ChatGPT to generate that, you can't explain how you came about with those answers.
But I mean, like with news articles and that sort of thing, like I've in the past for assignments read newspaper articles. If you're then using newspaper articles like the ones you're speaking about now, then they're based on false information as well.
But then you start with your primary sources, look at what the cases are saying, what the courts are saying, and then from that, and then go. Your lecturers, I think 19. I don't know any lecturers in this university. I can't speak for other universities that are using
Exclusively.
that are exclusively relying on ChatGPT. So journal articles are also a good indication to look at the interpretation of primary sources as well as books. And then from there, if you're looking for truth, I suppose once you have that basis, then you can then navigate. Is this true with what actually took place in this case, going back to the original case? So you have to kind of do your own investigation and then form your own opinion, which would then be an informed opinion.
I agree with your lecturer wholeheartedly. I actually do, because one thing that I didn't realize as a student is that having the luxury of time to read a whole case, to go and read the whole journal article is actually a real privilege. A lot of what we do in practice is what we call just-in-time learning, where you get a novel problem, maybe you haven't grappled with this area of the law in a while or ever, maybe no one ever has, because as you can see, those problems are popping up all the time. In that case, leveraging AI in a responsible, thought-out way is incredibly powerful. So, for example, let's say now you have primary sources, like I have a Puppy GPT, and it has access to the Act, the regulations, the case law that we have so far, the guidance published by the information regulator. It is strictly prompted to only respond with reference to the resources I have given it. It's not hooked up to the web. I have seen where it has strayed a little bit and then I've gone back and been stricter. And that is actually a really great tool to...
You can throttle it.
Yeah.
Okay, talking about throttling.
I think Brady wants to throttle people.
I think you mentioned that a word about how ChatGPT. I think you was using a word to describe how it fools people or something. There was one particular word that you used. I'm not sure if it's not something that is a common term. But yeah, I think there's a lot that needs to be unpacked here. I think the fact that ChatGPT writes so well plays significant parts in fooling people because you believe them to be the oracle, or it's the oracle that it's not necessarily. It's been wonderful. It's been very interesting. I think there's been good comments and good debate about this. Thank you to our two presenters this evening. Been very interesting. Thank you very much. We will get the recording up as soon as possible and share it with you. And we look forward to next week's session in particular. It's going to be back upstairs in 2027. We're going to be very lucky with our speaker, our guest speaker there, really a leading expert. I think we could agree, probably the at the moment in the context of South African law at this stage, and probably also one of the leading experts worldwide. So please spread the word. We look forward to seeing you all in 2027 next week, Wednesday. Yes. Thank you. Thank you very much. Have an enjoyable May Day, Workers' Day.
Yay!
Celebrate safely.